so much for joining us today in this panel discussion and, for being a wonderful part as well. So we have in a panel discussion that is, fourth panel discussion that is defending IP rights worldwide, non-litigation versus litigation. So we have Ms. Lijun Chui, Counsel, Clifford, Tsen. We have Mr. Jaroslaw, from Managing Director, Malaysia, and Lead Counsel Asia and Regional Compliance Officer Asia from Siemens Logistics. We have Mr. Gregory, Registered U.S. Patent Attorney, Ms. Lily Tsen, General Counsel, Amcor Flexible Asia Pacific at Amcor, Ms. Beatriz from Data Protection Officer EMEA NEC Group, and Ms. Min Hong Merchant from General Counsel Genome Medical. So thank you so much for joining us today's session. And we have a moderator, that is Ms. Lijun, and she is unable to speak due to this technical issue.
But at least we can see her, so that's not that bad.
Yeah, right.
Well, I don't mind starting off. I think we had a list of questions that began with me, actually, about the recent trends in the United States in patent protection and post-grant proceedings. And so I will briefly note my comments on that. One of the things happening recently in the United States are a lot of cases about eligibility, mostly relating to software or computer-implemented inventions. Many of you might have heard of the Supreme Court Alice case in the United States. There's also a more recent case called American Axle, where it was very surprising to people like me. It's a mechanical invention, but the court decided it was not eligible subject matter. And it's a kind of a quirky, strange case. It really was kind of what I would call a functional claim. And it's more of an enablement that the patent holder didn't teach the skilled person how to practice the invention. It seems like more of that kind of a case than really an eligibility or patentable subject matter case. Other things going on in the United States is there's in the Patent Trial and Appeal Board at the Patent Office, they have a new fast track appeal they just announced for examination appeals. And also another trend we're seeing in the United States is over the past few years, litigation seems to be kind of trending in a downward direction. I think part of that is due to the prevalence of inter-parties re-examinations and other post-grant proceeding at the Patent Office at the PTAB. I think litigation peaked in 2013. And it's kind of trending down, as I said. We're still seeing a large proportion, about a third of the patent infringement lawsuits filed last year in the United States were by the so-called non-practicing entities. Some people call those patent trolls. I don't use that terminology, but those are the kind of the big trends that we see in the United States right now.
Hey guys, this is Min. I actually have no problems using the phrase patent trolls. I've come across them often in my career and have had to defend them. And just strategically, I think what we find for companies is that it's extraordinarily expensive to defend them through litigation. And because the settlement values are very nominal generally, I think you really get a very bifurcated path where you either just end up settling again and again and again for hopefully nominal amounts, or you take a very scorched earth approach and you move aggressively in defending your lawsuit against all such patent lawsuits. I think that path of that scorched earth approach does send a very strong signal to the market that you don't have a tolerance for these types of frivolous lawsuits, for example. That does come with a really hefty price tag to do. And so what I've done is, in certain instances, depending on the risk profile or appetite of the company, I'll determine that the best course of action is to settle for a nominal amount. I've used outside counsel explicitly chosen because they have defended those very cases before for other parties, and I've been able to leverage their filings so that the cost of the defense of the suit has been reduced there, and then moved forward where especially where they've had a relationship with that opposing counsel, and in that manner strategically try to again reduce the cost of those types of more frivolous lawsuits. This is again on a very U.S.
Thanks, Min,
based
for that. I hope everyone can.
Yes, loud and clear, Lijun.
Sure, thank you. So sorry for the issues earlier. So I think Greg and Min has very sort of politely and nicely stepped in for me. And I think we wanted to ask everyone to give a brief introduction. That has probably been done. And just to give a quick roadmap in terms of where we're headed for this discussion, we have Min and Gregory who brought us through some of the US trends. And I think moving on from that, we would want to cover some of the non-US trends. And then from there, move to a more thematic approach in terms of the non-litigation and litigation methods that could be taken towards the approach in defending IP rights worldwide. So welcome again to everyone on this session on defending IP rights worldwide. So thanks again to Gregory and Min for covering the US issues. So I think perhaps just moving out of the US for a bit, Gregory, could you share your experiences in perhaps European patent oppositions and some useful measures and strategies? Because I understand that your experience goes beyond the United States of America.
Yeah, and I'll just briefly touch on that sort of further to the introduction. I worked for 12 years for a company called Hollister Incorporated, and their number one competitor is a company called Coloplast in Denmark. And Coloplast is publicly traded, so they've announced in their annual report, I think this was in 1999, that they were going to have what they called an aggressive patent strategy. So the way that manifested itself was we felt like they were patenting things that weren't really patentable in our opinion. And so we ended up filing many oppositions. When I was at Hollister, typically we would have 25 to 30 patent oppositions pending at the European Patent Office. And looking back on the work I did there, leading the teams for oppositions, I think I was involved in about 100 patent oppositions over that sort of 10 or 12 year span. And so from my experience, the takeaways I have are, first of all, if you're going to oppose a patent in Europe, it's much better if you have one or more prior art references that are novelty depriving, because it's very difficult to get the European Patent Office to sort of second guess the examination division on issues like inventive step, and even on other issues like insufficiency or expansion of scope. You know, in Europe, you're not allowed to expand the scope of the claims as you go through the process of examination. But you can, I mean, if you have a really good argument, you can maybe win, but you're much better off, and that's probably true in the United States too, if you have a novelty depriving prior art reference. The other things that are helpful, I think, that in my experience is, if it's a very important patent, for example, if it's a patent that has been asserted against your company in litigation, it makes sense to file not just one, but multiple oppositions. We had that happen successfully, where we would file 2 oppositions, one maybe quickly when we realize there's litigation, and then one later on closer to the 9-month window closing, where you might have more search results and more prior art. So there's sort of the advantage of timing, and also during the oral proceedings, each party gets to plead their case. So if you have 2 opponents and you see the first opponent made an argument that maybe didn't go that well, the second opponent can make a better argument or different argument and perhaps win that way. So that's another thing. And I don't mean to discourage people from filing oppositions, because I think the statistics show that almost 70% of oppositions result in either revocation or at least narrowing of the patent. Another thing, and this is very sort of maybe self-serving, but I found that when I, as the in-house patent counsel, was involved in preparing and presenting our case at the oral proceedings, we had a much better success rate. So, for example, if I didn't go, the statistics showed we'd win about 50-50, so sort of what I call a coin toss. You know, you might win, you might lose, sort of even odds. But when I did show up, we won 88% of that. And I don't think that's just me. I think any in-house counsel brings that value to the table as a member of the team in front of these tribunals. One other thing that's really minor, but for an important market, is if you're worried about German court proceedings, sometimes people will file the opposition anonymously, but if you want to have the best rights you can have in a German court proceeding, you want to have your company up front, named party, because there's this very narrow estoppel where claims can be construed narrowly in Germany if the patent holder made an argument about narrow interpretation during an opposition in the European Patent Office. And I wasn't even aware of that until recently. But we never filed these anonymous oppositions. Maybe we did one, I don't know. But so those are kind of my takeaways. And I know I've thrown a lot of information out there. So if anybody has questions, feel free.
Thank you, Greg. And perhaps I can direct the question at Beatriz. I understand you have the role as a data protection officer in Europe. So we hear so much about data being the new oil. So one question that I get quite frequently is there any IPR in data, and what are some of your strategies for protecting your company's data or perhaps even monetizing it?
Well, as you mentioned, of course, data is the new oil. I think that the value of personal data has already changed IPR strategies and business models. We see recently all these new movements with regards to digital markets and new technologies are rising on. So I think that from a European point of view, in Europe, everyone has the right to the protection of personal data. But intellectual property is also a fundamental right. So what is clear that those rights can sometimes be in conflict. So I'm not going to discuss all the GDPR right now, but I would like to highlight at least what I think which should be the 5 top interactions between IP and data protection. The first one is related with patents. That it's clear when a person or company applies for a patent, it is necessary to identify the applicant when filling the initial application. So we need to identify and disclose personal data of the inventor to the relevant patent office, otherwise the application cannot be successful. So under the GDPR, what is the challenge? That a corporate applicant may disclose personal data of EU resident inventors without their document an affirmative consent, which can be easily withdrawn. So if an inventor objects to the disclosure information, pursuant of course to the GDPR, the Europe Corporation is in a place or in a position of having its patents applications in the US refused because they fail to meet regulatory requirements or facing monetary penalties due to the GDPR and being forced to withdraw the disclosed personal information in addition to any other civil remedies. Moving on and adding to this, the person can even exercise their right to forgotten. So any individual can demand that their personal data can be erased. So it also applies to EU, but also to non-EU organizations when providing services and goods. So upon that objection of the employer inventor, the EU entity could be precluded under the GDPR from disclosing any information related to the residential address of the objecting inventor. Other issue that I would like to highlight is when we are talking about the right of access. You know that individuals can obtain a copy of all the personal data that has been collected about them. But what is the kind of information that data subjects are entitled to? I would like to highlight a case that it happened a few years ago. A French journalist who has been using an app, a dating app, she exercised her rights of access and asked the company, right, to send her all their details. The company, of course, sent the information, but refused to give her the information on how her matches were personalized using her information. So this company object that matching tools are a core part of their technology, right, and intellectual properties, and they will not be able to share that information with this particular person. Another challenge is the right to portability. This is the right to help data subjects to switch from one supplier to another, right? And data subjects have the right to receive their personal data in a structured and machine-readable format, which they can then forward to someone else. But who are these someone else? Because this can be a competitor. So the right to portability raises issues for those who may take the view that providing personal data in a way for potential competitors would be also an infringement of their IP rights, or at least disclosure some know-how. Profiling, that it's another issue. And for not bothering you so much with the GDPR, which is not the subject matter, but I think that the enforcement of the IP rights, it's also a challenge. When it comes to enforcing IP rights, it's difficult to identify infringers and the various actors involved in the distribution chain, especially when we are talking about products sold in internet, and because they are collecting and processing personal data. So I think that this situates a potential conflict between, on one hand, data protection, and on the other hand, protection of IP rights, which requires extra safeguards and transparency within companies.
One comment. I think that raises some great points, Beatriz. I think one way, perhaps, and I'm asking, it's more of a question than a comment, perhaps, is if, for example, when the company has the inventor sign the assignment of the invention to the company, can the assignment have language where they're acknowledging and waiving the sort of right to their personal information to the extent it's required for the patent application? For example, name, country of residence. I'm not sure what all the requirements are in each country, but sometimes even an address is needed, like a street address.
Yeah, of course. And there should be also an agreement, internal agreement, right, for transferring that the invention or the patent application. And of course, you can add any EU data protection laws requirements. Yeah, I totally agree with you.
Yeah, that makes sense. Thank you.
Thanks, Beatriz, for sharing those perspectives with us. And perhaps I can just ask Jaroslaw to very quickly share with us sort of your views from an Asian perspective.
Yeah, obviously, there is a lot of intellectual property rights in data, because that goes without saying, but we not only talk about how to protect them, but also how to potentially prevent from potential infringements, because especially in Asia, many of the data are covered not just by the personal data protection, but obviously if you talk about commercial data that fall under, for instance, anti-unfair competition laws, like in China, where there is a bunch of the administrative rules that are also aimed to protect the data of the company, and this data can be either subject to copyrights or patented technologies, etc. So we talk about really broad scope that also remedies that could be assigned to potential our opponents, how they would like to make use of that. So even if you don't have patented or copyrighted technologies, data, etc., still they can refer to administrative regulations in respective countries or jurisdictions to try to win something, not in the, I would say, civil way law proceeding, but by exactly putting the pressure that they can exercise under the administrative regulations. So I would like to make the point that there's also a number of the administrative regulation dimensions that must be taken into consideration once we are handling and protecting also our data.
Thank you, Jaroslaw. So now I think moving out of the sort of the geographical approaches and focusing more on the non-litigation methods of protecting your IP. This is a question for Lily. So we know that avoidance of litigation, if possible, is probably for the best, at least from a business perspective. Now, with that in mind, what are the key issues which you usually consider in formulating an IP protection strategy for your company and its products?
Yeah, thanks for that question, Lijun. I think, obviously, I'd agree that generally speaking, avoiding litigation is, if it's all possible, because sometimes it's not possible, is certainly the best and the most cost-effective route. But I guess the caveat to that is unless, in some cases, organisations do in fact have as a strategy themselves, predicated on prosecuting and defence. So, obviously that's a different kettle of fish that we're talking about. So, assuming most organisations do want to avoid being involved in, formal legal proceedings, from an avoidance perspective, there's obviously a number of key different issues to consider when you do formulate your IP protection strategy. I think, it goes without saying that one of the fundamental things to understand is actually where your most valuable IP and IP rights actually exist. And this is a really simple concept which often gets overlooked. For companies, this could be, very well-known example in the form of a trade secret, such as a secret formulation of Coca-Cola. But you really need to understand where in your organisation your IP rights that you need to protect and which you want to leverage as part of your organisation moving forward actually reside. For other companies, it could be in the form of goodwill, which has long been developed behind a leading name or brand, thinking of people such as your Nike or Ferrari. And other companies, for example, it might be recognised that, innovation or development isn't exactly their core strength. And, therefore, developing the innovative capabilities, from scratch isn't the most sensible things to do. So in that perspective, it might be part of the business strategy to go out and acquire another business or, for example, individual talent to fill that void and, therefore help to move that company, faster than what it could otherwise, move forward by itself. I guess in that context, if you're acquiring IP assets and that is part of your company's strategy, then it's fundamental that you understand exactly what intellectual property rights are being bought into. Is it, and this is something which should be done as part of your due diligence process. This is part of a registrable, design or a patent. Is there new material technology or applications that have some sort of groundbreaking potential? Does the target that you're looking at have an established R&D centre? Is it, in fact, for example, a key individual or a suite of individuals who are looking to, I use the word poach, possibly from a competitor? I think we had, was it Scott from IBM from a previous panel discussion. He was the master inventor of IBM, having a number of patent applications under his name. Is it one of those people that you're looking at to actually add value to your intellectual property portfolio? Regardless of any of these strategies, which direction your organisation wants to take, you really need to understand who else has a stake in that particular target you're trying to acquire. For example, does that success rely on the inputs of anyone else? Sometimes people will go into an organisation or go after a particular individual thinking that will be the be-all and end-all to everything. It may not be the case. There might be someone else who actually has significant inputs or significant rights in relation to that particular stake that's being claimed. Obviously need to understand what sort of skeletons lie in the closet, for example, any existing or potential infringement claims which you need to be aware of. And also, what's the competition doing? And that's something which I'm always asking my organisation to keep an eye out on. What is the competition doing? What is the next best alternative to what we might be acquiring? So I guess in terms of looking at, how you want to position yourself from a non-litigation perspective, I think it's important to stress that, oftentimes whilst your IP rights may exist in your tangible registration, such as your registered designs or patents, people often forget that the source of the innovation which leads to that development of a patent or design is in fact in the, human capital. It's the brain power of those individuals who actually come to that particular innovation. So if that's the case, you really want to make sure as well, and this is another point that's often overlooked, that, IP strategy has a multifaceted and multifunctional role to play within the organisation. And in this case, it would be one where, for example, HR needs to be involved to make sure that you've got robust employment contracts in place with, relevant, hopefully enforceable non-compete terms. You've got very clearly communicated internal ownership policies. And that the individuals themselves understand that if they are contributing towards, a particular innovation, that you will defend it, and there's going to be ramifications if they were to remove that asset or divulge it to someone, whether in the course of employment or otherwise. But, I guess, depending, obviously, fundamental, you need to understand your strategy. There's a number of ways to go about it. But, I think, in order to avoid litigation, you need to look at it from a multifaceted approach and think about the actual, where the asset exists and who is behind it, and make sure that there's, you've actually tackled it from all angles to have a complete 360 view of where those potential risks might lie, so that you align that, properly align that with the risk appetite of your organisation.
Thank you, Lily. So I think we have about, perhaps not more than 10 minutes left for this session, and I'd like to encourage all the participants, if they have any questions for us, to put it into the chat. I think just moving from a non-litigation perspective to a litigation perspective, we've talked quite a bit, and I think recently there's been a rise of the use of ADR, alternative dispute resolution, particularly arbitration, in relation to the resolution of IP disputes. And I don't think we sort of intended to go through the usual points about confidentiality, comparing the pros and cons there between litigation arbitration, or the technical expertise aspects of it. But I think 2 points are worth raising. The first is that I think in a global sort of context, we're talking about multiple proceedings in various jurisdictions. And one attraction of doing it via the ADR route is to have everything consolidated within one forum, as opposed to enforcing it in multiple jurisdictions, with potential options for the election of one governing law for your different types of IPR, at least on a inter-parties basis. Which brings me to the second point, the binding effect on third parties. That is a hot issue in terms of electing for ADR when it comes to enforcing your IP rights. Simply because you can't have what is a consensual mechanism, which is arbitration, enforceable on third parties, which affects issues to arbitrability. And I suppose one issue to think about is whether you are acting as IPR holder, which means that you're more likely to enforce your IP rights against the else in the world, and whether you're sort of in the position of a user or a licensee, which you might then wish to take on different kind of dispute resolution mechanisms that would enable you strategically to prolong certain proceedings or to defend yourself more effectively. So just with a quick overview on those issues, I wanted to invite Beatriz perhaps to share any thoughts you have in terms of preferences for dispute resolution processes in protecting your IPR. I'm not sure if it's just my issue, but
I'm not hearing Beatriz either.
Sorry. I was on mute. Sorry. Well, I was trying to say that, of course, it depends the type of IPR that we are talking about. My preference, how the situation is in Europe, I wouldn't recommend, in mostly of the cases, go to the courts. But between mediation and arbitration, it depends what you want to get. I mean, to me, and what is the company is the strategy of the company, in mostly of the cases, we go to an arbitration instead of a mediation. But you need to assess the pros and cons. To me, the mediation, right, I mean, you can sign an agreement as a final decision, right? It's more, it's good if you want to have a future relationship with the competitor you are looking for, and also it can be less time consuming and more flexible within the companies. But I do believe that arbitration, of course, that it's better than a litigation or going to the court, right? Sometimes it's challenged when you have multiple and when they need to deal with complicated disputes, right? Also, a good thing of the arbitration is the confidentiality, right? This is tries to mitigate the public damage of a legal dispute, of course. And also, I think that arbiters frequently work together and sometimes can be discriminated. And of course, you have always the chance to appeal if the companies don't agree with the litigation, with the arbitration appeal. But I think it depends. I mean, it depends on the company, what you are looking for. If it's just like a multiple countries, yeah.
Thank you, Beatriz. So
You're welcome.
a question for Jaroslaw. I think that we have a menu of dispute resolution options. Now, before we even go there, perhaps you could share with us some of the considerations, including any business considerations in deciding whether to pull the trigger to commence litigation or arbitration. You spoke previously of legal glasses and the business glasses in making this decision. Could you just walk us through that?
Yeah, of course. Thanks a lot, because that's, I would say, especially the very valid question for non-lawyers. Because I'm a lawyer by profession, but I'm holding the dual role when I also am responsible for the business relations in one of the country in Asia. When all the time they push us, even the way you asked the question, when you said what are the issues, we just see the opportunities. It's how the business works. We see only opportunities and some challenges. So obviously, when you think about litigation or any type of the dispute resolution, you all the time need to think whether you are concentrating on the short-term profits that could be potentially worth the damages, or you want to think about your future. And that's, I would say, the business glasses I normally put. I think about what is the long-term perspective, what is, because whenever you end up either arbitration or litigation, in order for you end up in a situation that in order for someone to win, someone must lose. Yeah. And that's the thing that you try normally in the business to offset. You try to create a situation when you have win-win scenario. In order to achieve that, obviously, that will end up either applying for some alternative dispute resolution, such as mediation, that could be always, and based on our experience, it's always a very good vehicle, or the negotiations that are aimed to secure long-term relationship, that are secure to create exactly this win-win scenario, because you never know who is going to be your customer in the future. One time it's you that is that you are the customer, that you are the plaintiff. That next time it will be another one. So if you think about relations, your reputation, of course you must be still persistent with enforcing your entitlements, preserving that if it's a part of your long-term strategy, how you would like to be also perceived on the market. Whereas if you are really think about yourself and the distraction to the core business, unless you are a lawyer, as you, Lijun, where you are making your core business is to going to litigate arbitration. Yeah. But in the business, we are not there. It's not our core business. Our core business is to focus on selling the products or the services, the one that our company is strong. And obviously the time and energy drainage that has been proven with the multiple litigations that we ended up either willingly or not unwillingly is basically massive. Yeah. And it does not really allow you to really run your standard business. So I would say I always advise all of my colleagues from the legal industry just think about what is really long-term perspective, and also looking from the both internal and external factors and origins, doing basically simple SWOT analysis. It will already be quite eye-opening, because maybe short-term profits will not really justify that you will lose the future. So that's the, I would say, business glasses I know I try to put on.
Thank you. That I think brings us quite nicely the session because I have my orders to try to commence the Q&A session from Harshita. Harshita, shall I hand it over?
Yeah. So actually, our presenter also waiting for for her presentation as well. So thank you so much for joining us today, and it's a really nice discussion. So we got a very good review regarding the how defending IP versus litigation versus non-litigation. So it's a very interesting session, must say. And now we are open for Q&A session. So can we have our question answer from our attendees so that our panelists can answer the question? And meanwhile, can we have a big smile so that we can capture this moment? Yeah, thank you so much. Lijun, can we have a smile, please? Thank you so much. Yeah.
We are doing our best.
Yeah, definitely, no doubt. So yes, we are open for Q&A session as well, and our attendees can ask their question in chat box, and then you can answer in the chat box as well. So as we have not received any question yet, so we will update you if we receive any question in the chat box or through the WhatsApp as well. So thank you so much for joining us today.
If we have a minute, I just had a couple points that I think we talked a lot about sort of offense, but on the defense side, and I wasn't aware of this, people in countries like Germany and the Netherlands, if you believe a competitor is going to assert a specific patent against one of your products or services, you can go to the patent courts and file what are called protective letters. They're filed under seal, and it's just basically telling the court, if this specific patent is ever asserted against this specific product, here's our side of the story. So it prevents a patent holder from getting sort of ex parte relief where the court only hears from them. And in the US, that's called a temporary restraining order, like very quick relief. And in the US, there's no such thing as these protective letters. But in Germany, you can file them in all 12 regional patent courts. And in the Netherlands, also, you can file these in the patent courts. And it's really a useful thing that not everybody, perhaps you are all sophisticated. I was not that sophisticated when I started with my company. I didn't know about these things.
Yeah, so we have a question from Ishani Chandra that what are your view on pre-litigation, I think, mediation as a method of avoiding litigation? Yeah, it's litigation.
So I'm happy to take that. Share some sort of thoughts first. First of all, I have to say I'm a big fan of mediation. I believe that as a process, it absolutely works. Parties who are willing and who are reasonable. That's it. I'll just caveat it. I think. Can you hear me?
Yes.
Yeah, we
can hear you, but we can't see you. So kindly open your video.
Okay, I think I might just put in my views in the chat if that will work better. So I'll perhaps hand over to one of my fellow panelists instead.
Okay.
Maybe I'll add in my perspective. But look, I think there's always a place for mediation, whether or not it's something which is imposed on the parties as a pre-formal dispute resolution process, or as a means for the party to try and come to some commercial understanding, which takes into account the factors which otherwise would be brought into dispute as part of litigation. I guess the advantage of going to a mediation as opposed to going straight into more formal proceedings, whether it's ADR or litigation, is that it enables the parties to bring to the table the soft factors for consideration as well, which is something you don't see and which you will lose as part of the formal litigation process. So that's something which I think parties sometimes overlook. They get very emotional about the dispute that they're involved in, and they just say, let's go to court. And then they forget that the court is very fact-focused and will be, the courts will follow whatever rules need to apply to actually come to an outcome. But it doesn't take into account the soft considerations which you otherwise would have on the table as part of a mediation. So that's just something that I think is important to bear in mind.
But plus, it's also very well.
I wanted to add to that. Oh, go ahead. Just really quickly, Jaroslaw, I just wanted to say that the other upside of mediation is, aside from the confidentiality part of it, is it allows for free discovery.
Yeah.
So you see where the pain points of the other party are. You see where their settlement posture might be. And even if it fails, at least now you know you could go on a little bit of a fishing expedition. So I think that there's very little downside to it.
Yeah, definitely. I just wanted to make exactly this point that, you know, basically the main risk of divulging confidential information because of the discovery procedure in the common law countries is already avoided. And obviously, mediation is so we have very good experience with the mediation in our organization, because it's very empowering for the party, because effectively the parties are in charge of the whole process, so they can decide what type of the evidence they would like to produce, how far they would like to openly and transparently talk about the future business, etc. So that's, I would say, always a good way for a dialogue to really avoid the arbitration or litigation, but not as the mandatory one. Based on my experience, we prefer more ad hoc type of the mediation, where really there is the willingness from both parties, because ultimately for them to get married, they need to it must be consensual. You cannot force someone to mediate with you and expect a good result. It does not work that way.
Yeah, and we also have a question from Pritesh.
I mean, I think that question for me, whether there's any legislative actions expected in the United States for patent laws in the near future. I don't know. I suspect nothing will happen this year, unfortunately, due to the pandemic. But I think there is some proposed legislation, and I'm no expert on this. I'd probably have to do some research, but I believe there's legislation that has been proposed that relates to some of these cases relating to subject matter, patentable subject matter. So there may be some patent legislation, but I wouldn't expect it for a year or two from now, and that's really kind of a guess. So I would recommend somebody research that and don't rely on my answer, because I'm as we say, shoot from the hip. I'm not really lined up for that answer.
Thank you so much for joining us today, and it's a really interesting session and also a very good interaction with you.